I would like to make reference to a report put together by Citizens Gavel.
Yes.
There were allegations of nepotism within Judiciary. What were a few findings of this report?
So one of our findings is that certain judicial officers, when they get to that, pinnacle, that top,
The peak of the career.
exactly, that they see it as an opportunity, to bring in their relatives.
own.
Unfortunately, in Nigeria today, you will find that it is even those at the helms of affairs that are usually culpable when it comes to corruption.
Judges are human beings. I know there is bribery in judiciary, but not all judges are involved in bribery. It is difficult to know the budget of judiciary in this country.
Oh, yeah.
Exactly.
Very, very difficult. Why? What are they doing there? I want to say that for those judges and the ones appointing their brothers, their sisters into judiciary,
Their
I want
whole
to tell them,
family
the world is watching
Wow.
them. Those people that are there, the world, because that means they have a double work to do. They are now there. They have to justify that I'm there not because my father is
Credibly.
CGN.
Yeah.
I'm there not because I am there because I am good. So for all of them, the world is watching them.
Good day, everyone. We're so delighted to have you here in this podcast. We welcome you. Here in this session, we're having discussions, not just discussions, but also recommendations around Nigeria's judiciary and how to make it better in terms of accountability and transparency. And I won't be having this discussion on my own. I have with me two brilliant, well-seasoned, well-experienced legal practitioners. I have here with me Barrister Olufolahan Awoyemi from the JDPC. You're most welcome, sir.
Thank you very much, Rita. It's nice to be here.
Thank you. We're honored to have you here. And of course, we have Barrister Sylvester from Citizens Gavel.
Thank you very much, Rita.
Thank you for your
I'm
time.
happy
You
to
came
be here.
all the way from Lagos.
Yeah.
Thank you, sir. So we are diving right into it. I'll be starting with the judgment delivered by the ECOWAS court regarding, the NSAS protest and the people who died. And please, I know you guys are well seasoned, but let's just make it as, plain and simple as possible for the benefit of those that are not well, conversant with legal jargons. So I'll be starting with the judgment delivered by the ECOWAS court regarding the NSAS protest. And then it ruled that indeed people died and it ordered compensation for the victims, families of the victims. So I would like to start by, this African adage, an African child never says, oh, my friend's mother's soup is sweeter than my own mother's soup. My mother's soup is the best, is the sweetest. So what happened to the courts within Nigeria? Why did we have to take what happened, in what we can even call the heart of Nigeria? It happened, people died. Why did we have to take it outside Nigeria? Is our judiciary not functioning? Is our judiciary just a mere cosmetic, institution that just pays salaries? And so what really happened? And then what can we do moving forward better? I'll start with you, Barrister Sylvester.
All right. Thank you very much for that question. It is indeed a brilliant one. I think that the reason why the applicants in this matter decided to take this matter, their case before the ECOWAS court, was chiefly due to circumstances, right? You will recall that during the NSAS protest, particularly on the 20th day of October 2020, when the incident happened,
Okay.
of course, people were killed.
Yeah.
And thereafter, you will recall that one of the applicants, who is popularly known as DJ Switch, actually went live on Instagram to show live footage of the incident that took place. How certain soldiers who were of course invited
Open fire.
Open fire on peaceful protesters and all.
Sir.
So thereafter, she, alongside several other persons who were present in that particular location, started receiving threats,
Death threats.
threats very well. And, it became so serious that they had to go into hiding, and eventually they had to, seek for asylum
Yeah. So
elsewhere.
why did we take this out of Nigeria?
Yeah, so here's the issue. Now, because she had to fled,
Yeah.
talking about DJ Switch now,
Yeah.
it was difficult for her to come back to Nigeria. And you would agree with me that in filing court processes in Nigeria, it is usually done manually.
Exactly.
Yes. And part of the process will include
The complainant coming in person.
very well. And that is difficult, right? And then the threat again from the government
Made
was
it almost impossible for her to come in person.
Exactly. So these are the issues. Now you would find that the ECOWAS court held virtually. So from the filing to prosecution of the case up to the point of judgment, everything was done virtually.
So it was just to preserve people's lives.
Essentially. So of course, this is part of the reason. But of course, this is not to rule out the fact that over time and due to incidences that had happened in the past, people were gradually losing faith, in the judiciary, in the sense that it became difficult for people to really believe that if they take their causes before the court, they would get justice, in return. So that could also inform why DJ Switch, as well as the other applicants, decided that, look, it is best we approach a neutral body, for the purpose of seeking justice. So that, to my humble self, is,
Thank you.
I think, the reason why she decided, and of course the other applicants.
So for
decided
fear
to
of,
move on.
to save their lives and for fear of victimization, to
Exactly.
protect their families, they had to take it outside.
Exactly.
Thank you very much. So, Barrister Fola, what recommendations, God forbid, but let's assume but not concede that we have this kind of incident again, that terrible incident that happened October 20. What would you recommend, people seeking justice to do? How would they seek justice within Nigeria's judiciary, not taking it out?
All right. Let me say a very big thank you to you once again for bringing this very topical issue into the public fora. I want to thank my learned friend for some of those issues he has actually dealt with too. But before I answer the question, I just want to take us back a bit. One of the prominent things that happened during the NSAS protest was, out of all places within Judiciary,
Yes, sir.
the court was desecrated.
It burnt it down.
Down.
Another important fact.
So, why? And that will give us an answer to the question.
So it makes it difficult to even seek redress, because the very house that should
dispense
justice was burnt down.
And the reason why it was burnt down, one of the reasons is because they don't see justice in this place. They feel like this is one of the key problems of this country.
So they were sending a message to the necessary authorities that this is more or less like a useless building.
They don't see justice in this place. There are other places around that place that were not burnt, but the court was burnt down. And so definitely it will be difficult for someone like DJ Switch, to come back and now bring the case to a place where they don't see justice. Because of so many issues, some of those issues we know, some of those issues we don't know in public fora, but we know they happen. It will be difficult for them to now bring their cases and say, okay, fine, let us now come and bring our cases to court so that the court can now give a judgment on it and some of those things and, stuff like that. So I think that's also one of the critical reasons why it's difficult for people like the Judiciary to come and bring, the case down to Nigeria, and then so that Nigeria can litigate on it. Of course, we all know other problems. It take time, political issues will come into it, so many other issues will come. Police will turn into something else. So when you look at all the issues herein, you feel like it's better to just go to a court that is also allowed by the law, which is an ECOWAS court, for them to go and get justice, and I'm happy that they got the justice. People have been asking questions, how would they enforce it? I said, okay, fine. Is the fact that I got justice is
It's
enough?
enough, actually.
The enforcement is something different, but the fact that this you got to justice and there is a court backing, there is a court order backing that this thing actually happened is enough, for DJ Switch and all the other people that were killed during the October 20 Enters project. And I want to say that since then and now, well, we're talking about the justice system now, nothing has changed. That's actually where the problem is. The court was burnt down. The court did not say, apart from the the panel of inquiry that was set up by some state government, some Lagos state government, and maybe a few other states. Even those ones that were set up, how many did you hear anything from them? Lagos state,
nada.
we brought out something. Yeah, we had something from Lagos state, but apart from Lagos state, maybe one or two other states out of the whole 36 states and the FCT, maybe just few other states came out. I mean, definitely the perception of the justice will be wrong. I said, nobody is there for me. This thing just happened and just life continues. So definitely that comes back to the issue why DJ Sweet and other people have to now go to a better place where they know that their rights should be compensated as we have now.
So what I can draw from you gentlemen is we need a complete overhaul and a complete revamp of our judiciary.
Definitely.
Essentially.
Definitely.
Wow. Well, still on our judiciary, we've practiced, litigation at some point, and I realized that each time we approach the court seems to be overburdened. I remember the last time I was in court, the judge said something about her having 500 cases to her name. So, and then whenever we present a case in court, they talk about, have you tried, the multi-door courthouse? For the privilege of those that don't know what that is, it's simply an alternative way of, resolving disputes, mediation, arbitration, just basically people coming together and saying, this is what I'll compromise, this is what I'll compromise. But my question is, are these outlets, these are multi-door courthouses, are they really, really working? Why is the court belabored? Why is a judge having 500 cases to her name? And then what are we recommending at this point to, ease the stress?
All right. So I think the problem is chiefly due to lack of awareness.
Okay.
So you find that most times when people have issues between themselves, the first thing they think of is the court.
Exactly.
Right. And that is really the issue. Most people are not aware of the existence of multi-door courthouse or alternative dispute resolution mechanism. So, of course, what you don't know, you can never make use of.
Exactly.
So, to that extent, the court is overburdened, like you said, because if virtually everybody would approach the court for the purpose of resolving their dispute, whereas there are other mechanisms available, then it becomes an issue. But Lagos, for instance, has been trying a lot in this regard because, of course, Lagos is one of the few states, I think, in Nigeria that has a multi-door courthouse where issues of, simple issues actually are resolved, right? And you find that, in fact, it is such that if you file a matter today, even though in the regular court, they could assess it and decide whether it's a suitable case for alternative dispute resolution. And if it is, they will send it to the ADR section and you find yourself there. So like it or not, you have to
there.
Exactly. So, but that is a way of, encouraging parties to actually
Settle
explore.
amicably.
Exactly. And then of course, where they are unable to, they are redirected back to the court.
Litigation.
Very well.
So you're saying it's a lack of awareness.
Lack of
Litigants
awareness.
don't know that there is a multi-door courthouse.
Exactly. And that is why we have cases upon cases upon cases before the court.
Oh, amazing.
Yes.
Barrister Fola, would you like to add to
Yes,
that?
I will. I also feel like talking about revamping the judiciary, some things needs to change. For instance, the example that comes to my mind that I said I'm going to talk about is divorce. Now, I have asked this question several times. Why will a case of divorce get to an high court? Why? Especially in the case where the couple have not been together for 3 years. The law is right. But you still have to come back to the high court. You still have to litigate. You still have to call for evidence. And the evidence is already there. The guys have not been together for 3 years. The law says 2 years maximum. You still have to spend sometimes 2 years on the case that the two of us are no longer together. Why are we wasting time? Why?
So you are recommending a legislative
Exactly.
amendment.
So when And there are issues like that when you look at it on sometimes on land matter. We are in court not because of ownership, not because of possession, just because you took
A little
5 meters
boundary
out of my just 5 meters out of my land, and we are in court because of 10 meters, 5 meters, and we litigate and we spend years and years, and what we could have resolved there. So there are some things that, honestly speaking, there must be legislation on, like the issue of divorce. I've always been a staunch believer that any divorce that property is not involved, honestly speaking, I don't know why it's what it's looking for in the High Court. Yeah. Except when property is involved and property has its own laws, the High Court has to legislate. I don't know the reason why you have to come to the High Court. I don't know. So there should be a legislative drafting amendment to some of those issues, and that will ease a lot of burden on the cost of it. Because in a lot of states, I know in your state, I know in few other states, if you know the number of divorce in their court case, if that is out, honestly speaking, they're going to be fine. To a large extent, they'll be fine. Then other cases, the ADR will now work for other cases they mentioned, and so many other stuff. Then another thing that I think we also need to work on is, I also ask myself this question. FCCPC, Federal Competition and Consumer Protection Council. I had a person sometimes ago, around 5 years ago. She bought a cake at a particular supermarket. I won't mention supermarket. And she saw that the cake is getting stale. And she reported to FCCPC online, and they took it up. And they have to be calling that supermarket and tell them, your cake, you have to do something. You have to pay, either you return and you pay compensation. FCCPC is not a court. Mm-hmm. And it did not take time.
But that's their actual duty.
It did not take time. Maybe within 2 months or 3 months, and they are already, if it doesn't take up to 1 month, they're already telling the particular supermarket to do what they need to do. Imagine that person has to come to a court. Before they serve the supermarket, 2 months has gone. Before they now say the case is for mention.
More rotten.
They now say the case is for mention. You now be there for another 1 year, 2 years, 3 years. And I asked the question, why? I mean, those are alternatives that people can also use. And they are working. I mentioned them because I know to some cases they are working. You understand? So apart, it's not all matters that we just say once we just happen, then you go to court. Yeah. There are other ways that we make mechanisms that we also need to try. For instance, look at the issue of CBN, banks, issue. People report sometimes to CBN even on their Twitter handle. And I don't know that you see, and they take action without, and this cheaper, is faster, is better than you going to go and file a matter in court, spending 2, 3, 4, 5 years. So these are alternatives apart from ADR that will help the justice system. We need to strengthen those institutions too, okay? So that since they are statutory institutions and they have the powers under the law to do some of these things, it will seriously decongest the court, and it will help justice system to be what it's supposed to be.
Yeah, to make delivery of justice faster.
Exactly.
So I'm so happy I'm with two brilliant players. I've been able to get 3 points from you. First, our institutions, our statutory institutions, they should actually function. Not everything should be reported to the courts. Secondly, more publicity should be given about alternative means of dispute resolution. So if you're a litigant or someone agrees, you necessarily don't have to file the case in court. Just approach, the multi-door courthouse for mediation. And then thirdly, there should be legislative amendments. Not all the matters should go directly to the High Court. A simple summary judgment can, decongest the court. So Thank you very much for that. So we are moving on, and we are talking about receiving bribes within the judiciary. Hey, I saw this report and I was shocked. I have an awe when I see a judge. It's not easy. Me being a lawyer, talk more of a judge. They have their big cars. There's this prestige around them. But this report said otherwise. They said they carried out research. The report was all over media, TV and stuff. Yes. So they carried out a research, and the research shows that, the judicial arm of government is the highest ranking when it comes to receiving bribes. And I was shocked. How does that happen? Where did they send the money to? So what perception does the common man have about this? Is now justice for the highest bidder, Barrister Fola?
All right. I'm laughing because of that question. Perception of justice. That's a very critical question. We as lawyers, we all know that justice is a three-man traffic. And one of them is justice to the public. And that is critical. Because like I said, when you ask a question about the issue of DJ switch, if I don't perceive that I have justice in the house of justice, then there's a problem. And honestly speaking, people see the court as a place for lawyers only. I'm serious. I mean, I've done this kind of thing before. They said it's just a place that you lawyers, you just, because they don't talk. They are the ones who are taking years to talk of, mention, take date, serve date, all those things, until they now talk maybe after 1 year. So, and after that again, they take another adjournment for 2-3 months for you to continue hearing. So it's just a place for you lawyers to, and you are still going to come out and the court said that this and this and this. You cannot file, you cannot do anything. So they see it as a place only for lawyers and judges. And that perception is wrong. Because when you take a case to court, the litigant, the claimant, or the defender is actually the main person. It's actually the one that should be at the driving process. And that's one of those things you achieve when you do a matter through a DR. You are the one that you're actually on the driver's seat, not actually your lawyer, so to say, except you choose your lawyer to be. All right. Now, so back to the question you asked.
Bribery. The
issue of the bribery, is a very serious thing. And I want to thank Gabriel for...
But do you think it's true?
Yeah. Judges are human beings. I know there is bribery in judiciary, but not all judges are involved in bribery. I'm sure it's not all judges. But let's take it a step further. We talk about judges. The judiciary is not only a place for judges.
Beautiful.
We have court staff. And all lawyers, we know what we face with court staff.
Yeah.
Even if Honorable Justice AA, as an example, wants to take bribe, I will not take the bribe to Justice AA.
It has to be true.
It will be to the court staff. So, and it is easier for a person, a public member, to see me talking with a court staff or exchanging money with a court staff. What that guy will go on is that judiciary is corrupt.
Yeah.
It's as simple as that.
I would just like to quickly chip in my story.
Yeah.
I got a judgment and my client was very finicky. So she noticed a typographical error. So I went back to the registrars that, please, there's an error here. And they were giving me that vibe. This is your English you are speaking. Just give me something. And so, I flared up. And then the lawyer said, you have to be careful with these people. They sometimes are more important than the judge.
Exactly.
So I had to retrace my steps. Barrister Sylvester, what are you recommending?
Right. So, like he rightly mentioned during his submission, I mean, the fact that there is corruption in the judiciary, you can't take that away. And unfortunately, in Nigeria today, you will find that it is even those at the helms of affairs that are usually culpable when it comes to corruption. Now, I'll give you an example. In the year 2022, the last CJN before the current one, he was accused by his colleagues, of corruption. He was set, I wouldn't know whether you remember, his colleagues at the Supreme Court wrote a letter to him, accusing him of siphoning certain monies that belong to them, among other things. That's one. And don't forget that he, as the CJN at that time, was the chairman of the NJC, that is the National Judicial Council, which is the body that is responsible for disciplining judges. So imagine that I am indicted now. How do I?
You have to, dispense justice by yourself. Of course, you will be very biased.
And that is the issue. That's the issue. Now, I have this recommendation that, there is need for particularly the NJC, right, to be headed by someone other than the CJN.
Exactly.
And my reason is that the CJN cannot punish himself when he errs, right? But assuming we have, for instance, a retired justice of the Supreme Court, someone who has, who has integrity, someone who has track record, in the justice system, if we have such a person heading the NJC, he has nothing to lose.
Exactly.
Right? I mean, if he decides to sanction or discipline a judicial officer, you can't threaten him by saying that you will not reappoint him or that he will lose his seat at the Supreme Court and all that. So if you have someone that is, dispassionate about issues that relates to the judiciary himself, having been retired, I feel it will go a long way to ensure that judges sit up. Then again, there is also a case of the current Attorney General of the Federation, there was a statement that was credited to him recently where he said the judiciary is actually for the rich. So that means that people like you and I that are nobodies.
I saw that tweet.
Very well. So how do we, who do not have access to some of these big time people, access justice, if indeed justice is for the rich, So that is on the other hand. Then again, I wanted to cite a case, that happened also in Kano State, where a magistrate had issued an order freezing certain amounts of money in a litigant's account. And then shortly thereafter, the magistrate went behind
and siphoned
the money, asked that a part of the money be transferred into her personal account. A petition was written against her, and eventually the State Judicial Service Commission sanctioned her. We applauded the NJC for that. But my thinking around, and this is my recommendation, I am thinking that, look, the NJC is not doing enough in terms of disciplining erring justices. And that is why some of these issues, keep on happening.
Exactly.
Right? So, for instance, now I'm not aware, I'm not privy to the fact whether, monies exchange hands, but the Emirate tussle that recently happened in Kano State, you would notice that the State High Court of that state issued certain orders, restraining one of the deposed emir, right? The Federal High Court of the sitting in the same state issued another order in favor of the deposed emir, restraining the current emir.
So that's like conflicting orders.
Very well. And meanwhile, elementary law tells me that the Federal High Court does not have jurisdiction over emirate issues,
this is more
right?
like chieftaincy
Exactly, chieftaincy issues. So I keep wondering to myself that what really is happening, and one of the orders, interestingly, came when, so let's assume that the law on which the current emir was installed, let's say it was, what do you call it? It was assented to, let's say around 5 p.m.
Mm-hmm.
Shortly thereafter, there was an ex parte order from the Federal High Court, suspending the installment of that emir. Now, that calls to mind how or within what period did the applicant got to know about the installation of this person, or even the assessment of the law?
There was obviously a backyard job.
Exactly.
So normally the emir issue is a state issue.
Exactly.
And you can't approach a state court and expect a ruling against the state. So they decided to do what we call forum shopping and go to the federal court.
And interestingly, the agency has a practice direction that prohibits foreign shopping.
Yeah.
Right? But for some reason, the Federal High Court decided to assume jurisdiction and keeps issuing orders upon orders upon orders. Now, like I said, while I'm not aware that monies exchange hands, but if you look at the circumstances,
it's fishy.
Very well, it is easy to deduct that, look, something fishy is happening. But I'm saying that the agency is not trying in this regard, because ordinarily the agency ought to call the courts to order, right? We know that there are courts of coordinate jurisdiction. But given the conflicting orders, very well, it will cause chaos in that state, because one faction will say, look, we have an order backing what we are doing. Another faction will say, we have an order backing what we are doing. And at the end of the day, there will be clash, right? Now, what the NJC ought to do ordinarily is to step in, to call both this into order, and then, if possible, make certain firm declaration, not just declaration, but sanction them even. Or at least one of the judges that would have been in the wrong be sanctioned, so that it will serve as deterrent to others. But we have not seen that.
So what's happening now? So the both orders are coexisting
at the moment, because they will tell you. I know that I think one of them also had gone on appeal. So
one of them is already on appeal.
Yes, very well. So that is pending. An appeal is pending over one of the distance. So eventually we will see how it pans out. But I'm saying that at least before then, the agency ought to take steps, right? And this then takes us back to the issue of the the incompetency of those that head the NJC. I'm talking about the current CJN, for instance, who is the chairman of the NJC. Now, he appears not to really be bothered about what is happening, because if he's bothered, he would have taken proactive steps. And that is one of the reasons why I would like to recommend that the NJC should be headed by someone other than the CJN,
Yeah.
right? So that in the event that the CJN is even found eventually to be culpable in the whole this thing, such a person should be able to have the power to sanction the CJN without let or hindrance, right? But at the moment, the CJN cannot sanction himself, and it makes things difficult. More so that other justices that are led by the CJN, of course, seeing that the CJN himself is not really big in, sanctioning or disciplining erring judges, of course, they will continue in their impunity. So that is what I think.
All right. Thank you so much, Barrister Sylvester. Let's just, for a bit, leave the judiciary space and, the allegations of corruption and the double orders and what have you. Let's talk about technology.
Right.
That's like our resting place. That's where we, connect people that are miles away, and our organization, Citizens Gabor, we jumped into it. We came up with Produce AI, which I like to refer to it as an electronic library,
Right.
a nerdy friend that answers all your related questions, all your questions relating to, Nigeria's legislative enactment and case law, anything Nigerian law. Produce AI has the answers with just one click away. So, I just want to share a story about my experience, with, trying to introduce a judge to, technology. I had this case and it was difficult serving the defendant, and I made an application, to serve him by email, and I was rudely dismissed. God, you can't, why is it in our law? Can you bring it? So, and there's this thing, there's this jackpot wave. People have left the country, but people still want to get justice, but they don't want to come all the way, to Nigeria. So people have had so many, views about it. They're saying Nigeria can't sustain it. They're saying the power is bad. They're saying it's expensive. I think we had a discussion,
Yes.
a while ago, and he said something about it being, 50,000 naira or
Yes,
something.
30 actually.
Oh wow, that's really expensive. So, sir, I'd like to ask you, Barrister Fola, are we really ready for virtual hearing? Is it something that can be sustained, or is it just for the rich people?
All right, thank you very much, Barrister Rita. I want to say that Nigeria, we have no choice. I mean, that's where the world is coming to. That's no longer the future. That is the present. All right, the virtual hearing in the justice system. But I want to say one of the reasons why a lot of our judges don't buy into it initially, just number one, a lot of our judges are old.
Yeah, no offense. Sorry to cut you. There's this meme or a joke that I collected 5,000 naira from my grandma to update our WhatsApp. So
Yes, exactly. So it's not an insult, but because they were born old, most of them, how they grew up,
Exactly.
so they are new to all these
And they are not conversant.
updates,
Exactly.
technologies. It's a big lot of stress to
For
them.
them.
Okay, so that's why some of them don't buy into it. All right. Then again, initially too, there was no law that was backing it up, and perhaps when you took that your application to court, that was actually the issue.
that was
there
the
was
issue.
no law.
There
So,
was
but
no
now
law.
we have the Evidence Act that now recognizes
That
electronic
imputes it.
evidence.
Beautiful.
So, and now I've started processing through WhatsApp personally.
Beautiful.
I've started processing through email to someone in
Amazing.
Kenya. So, I mean, I've
Wow,
done
outside
outside
jurisdiction.
jurisdiction, and
Beautiful.
we used it in court, high court for that matter. So it's been working well. It's been working fantastically well. So, but I know that again, it's normal when your process is just starting. There will be some issues at the
Exactly.
beginning, issues of network, issues of so many other Nigerian issues of electricity. Like maybe I'm sure
When
after
we
a
keep
while,
using it, we'll
definitely
learn
we are
to
going to get
smoothen it
into
out.
it. And when the issue of initially in the 70s, in the 80s, we were typing through typewriter.
Exactly.
But now
We
computer
advanced
came
the
in, and
computers.
we all recognize, we all do computer evidence now. We all do all sort of things. We all type in comfort of our offices using laptops now. IBM came in, the laptops now, and we are all fine with it now.
Very
Okay.
well.
So I'm sure after a while too, definitely we are going to be fine. We usually fine because there is no other way, to go about it. But that is just one part of virtual hearing for court processing. Another part that we also need to also mention is also the issue of recording for judges. All right, which is also critical. A lot of judges still
Long
write
hand.
long hands and all those things like that. So we need to actually have a way to deal with it too. But it's also important for us to understand that we cannot totally eradicate recording in long hand.
So that they don't alter the court process.
Exactly. Then sometimes some of those judges that they still write in long hands, apart from the fact that there is an answering machine, they want to hear it by themselves. If you are recording, if your voice is recording, if you say the voice will record it. If you say the voice say, oh my god, the voice will record.
There is a chance that the recording is not verbatim, is not accurate.
There is a chance. Then there's a chance that it takes more than what the relevant things. So the judge will want to still write down the relevant things so that when she's writing her judgment or making her ruling, she can
have the succinct points.
Exactly. Then if you want to know more, you go back, to the recording. So those are things, that are there. I'm sure again in the future, there might be an app. A lot of high courts now in a way are trying to be on website. None of them were on website 5, 6, 7 years ago. A lot of them are now on website. I'm sure very soon. Now in your state there is affidavit evidence online, electronic evidence.
Exactly.
And that is you can never imagine that some years ago it will happen. So I'm sure gradually you are going to get to a time that people are talking about. You're in the comfort of your office. Then you can actually do your processes, file, pay through your card, get your processes,
everything electronic,
and they are still down in your office. So I'm sure we are going to get there, after a while, but we need to just start with this process.
Thank you very much. Barrister Sylvester, would you like to say anything?
Yes, I mean, he has touched on most of the points, but I would like to speak to the cost of, putting up or setting up
the virtual hearing.
Right? Like you rightly mentioned, the cost of posing the question. Litigants at the moment in Lagos are expected to pay certain amount of money for the purpose of setting up.
What is that money for?
Well, they will tell you that, they buy data, internet, for the purpose of the virtual proceedings. And interestingly, because they have limited
Sorry, can
gadgets,
I just interject again?
Yes,
I think there's a budget for the judiciary. So I think all these things should cover it. Why should the litigants be paying for that? Then if the litigants are paying for that, what really is the budget for the judiciary for?
Thank you very much. So that I was actually driving there.
Okay.
Now, you would find that it's actually possible that there is a budget for that, right? If there is, then of course it is absolutely wrongful because it was a directive issued by the chief judge of the state saying that going forward, if any litigant wants a virtual proceedings to be conducted in respect of his case, he should pay so amount. Very well. So now, but if there is a budget for that, then it is totally wrongful because those things are infrastructure that ought to be in place in the first place, right? But again, what I understand at the moment is that not all the courts are actually, they have the gadgets for the purpose of, to accommodate virtual proceedings. I did one recently, in respect of one of the cases I was handling before, or I'm handling before a magistrate court in Lagos State. And I actually did that before the directive for payment of 30,000 naira came up. So I was lucky, so to speak. But, the registrar, the ICT registrar had to come from the High Court. The court I went for, the magistrate court, was in Yaba. So it was a distance, right? But the ICT registrar had to come. He had to bring a television, the big size, and then the internet facility and all that. He had to convey all those gadgets.
It's a whole setup.
Very well. Down to the magistrate court for the purpose of that virtual proceeding. So they would tell you, by way of justifying the 30,000 naira, that is
paying for logistics.
Exact, for logistics, So, but going forward, the question is that how does that affect access to justice? Because imagine a poor litigant coming before the court, and for one reason or the other, let's say the person, a key witness that ought to give evidence in respect of his case, which would actually probably guarantee his success in that matter,
is outside
the country or even outside the state and cannot come back to the state for the purpose of giving evidence. What happens if this litigant cannot afford that 30,000? So it's actually dicey, and that is where it goes back to the state government
having a separate budget for people who elect to use virtual hearing.
Thank you very much. So if we have that in place, then of course it would, it hasten, the
pace of justice delivery,
right? And I would like to also give you another example. I went for a matter. It's a criminal matter actually before one of the high courts, and the prosecution had called about 5 witnesses. His last witness is a pathologist, right? But the last witness he brought was sometime in February. And since then, he couldn't put in his pathologist because the man, firstly, is a professor. He has just been appointed a special assistant to a particular governor. And so he's too busy to come to court. It was one adjournment after the other, from February till date. In fact, a new date has been given to us in October for the purpose of the pathologist to appear and give evidence. Now, had virtual hearing been applied for, because the prosecution actually has an opportunity to apply for virtual hearing and the court is most likely to grant it, but he failed to do so, right? We had made an application for the prosecution case to actually be foreclosed, but the court said, oh, you know what, let's just give them one more adjournment. But I think the point I'm trying to make is that if the prosecution had applied for a virtual hearing, right, let's say in March, it would have been granted, that person would have given evidence virtually, and by now would have probably closed our cases, adopted our final written addresses and all that. So you could see how virtual hearing would have facilitated the pace of justice delivery, right? So yes, like my learned colleague mentioned, technology is actually not just the future, but the present, and we need to embrace it.
We need to embrace it. Thank you very much, Saz. Okay, we're gradually coming to the end of our podcast, but I would like to make reference to a report put together by Citizens Gavel. Yes. There were allegations of nepotism within Judiciary, and I must commend you, Barrister Sylvester. I learned you were part of the, people within that project. So, what were a few findings of this report?
All right. So, thank you very much. So, the report actually centered around judicial officers who, at one point or the other, had their family members, as part of the judiciary. And the interesting thing is that we tried to look at those judicial officers who are actually in a position of power, who are actually in a position to influence the appointments of, their relatives. And so we decided to go back in time when the first Chief Justice of Nigeria was appointed, Honorable Justice Ademola, and we trace that,
that name kept on repeating itself
over time. And so also with other Chief Justices of Nigeria,
and
such as
didn't seem like a coincidence to you.
No, not at all. So it would seem that, one of our findings is that, certain judicial officers, when they get to that, pinnacle, that top,
the peak of the career,
exactly, that they see it as an opportunity, to bring in their relatives.
Own.
Probably it's a way of rewarding my family members. Come in and join me. It's time for us to share in the national cake.
Okay, so let me just give an argument for that, or what people would say.
Yes,
but they say why they are qualified. It's not like they took a BSc holder and put them there. So they said they are very well qualified. They weren't dull in school. So why not?
Very well. So I would now counter the argument by asking, why were these relatives not in the judiciary before this person becomes who he is? Right? That is the question. And let me also drive home my point by using the current Chief Justice of Nigeria. Now, when he became the Chief Justice of Nigeria in the year 2022, a year after, 4 of his relatives, took up key positions in the judiciary. His younger brother became an auditor. He was promoted as an auditor of the National Judicial Council. His nephew was promoted as a Court of Appeal justice. His son, who has never been a judge or a magistrate, so to speak, was appointed, as a judge of the Federal High Court.
Oh, wow. So can you just jump from being a lawyer directly to being a judge?
Yes, so if you are qualified, you have the legal qualification.
Exactly. Yes. So, the law, I think, prescribed for 10 years as justice.
So did he have that?
But usually the argument is that you should at least be a magistrate so that you have that experience. It's not really easy for you to just be appointed from the bar to the bench, and then, it would take longer time for you to acquire, but of course, very well, the requisite knowledge for the purpose of dispensing justice, So most of the times, arguments have been in favor of, magistrate moving, or appointment moving from the magistrate level to high court. It's usually easy because these people have tested the nuances, that has to do with, dispensation of justice and all that. But you will find that most of the times, most of the appointments that are done are usually because the persons who are in power actually had that influence, and that is why their relatives are.
And there's hardly any other power to alter that decision.
That is the position. One way or the other, you would find that is the case. And so in our report, we made certain recommendation, right?
Yeah.
We said that, look, okay, so the argument you just put forward,
Yeah.
we actually anticipated it and therefore decided that, look, in situation where, for instance, I'm the Chief Justice of Nigeria and as well as the chairman of the NJC, and one of my relatives is coming in, maybe he or she also put in an application to become a judge, and I know that it will come before my table to approve. That in such a situation, I should recuse myself. Right?
And raise a hand like
Exactly,
there's a conflict of interest here. Can someone else
should
validate this?
Should sit and then decide whether to approve of this person.
That's
or
a
not.
beautiful
That is
recommendation.
one. But we are saying that is not even enough, because there will usually be eye service because the CJN's brother.
I cannot go against his visual. I don't want to be victimized later.
Exactly. We made a further recommendation to say that, look, in such instance, the NJC itself should step aside and outsource it to third parties. To a third party company.
People that really will not be affected, or people that they don't have reach to.
Exactly. Neutral bodies, outsource it to them, let them do the recruitment process. And even if it means in respect of this particular candidate, it's not bad. Or if you decide to give the whole candidate to them, go through the list and decide for yourself, these are the rules. Once there is compliance, then give us your feedback and we will adopt it. If that's the case, I think that would, and it speaks to transparency.
Exactly.
Very well.
And it makes the process very credible.
Exactly. So these are some of our recommendations in the report.
Thank you very much, Barrister Sylvester. Barrister Fola, would you like to add to that?
Yeah, I have a few things I want to add to what
sir.
my learning
Very well,
brother has just said. All right, on the issue of the corruption, I want to say that because you mentioned that we should make recommendations of what we should do, and my first recommendation should be that for either a court staff, either a judge, either a magistrate or something, at every state judiciary or federal high court or court of appeal or anything, there should be a place I can report a corrupt official.
Like I think we have the Ombudsman. Is that still functional?
Not really.
I've been hearing that name since I was preparing for current affairs in primary 6.
And we don't even know what they do.
So there should
Ombudsman.
Exactly. So there should be a mechanism where I can report, maybe a WhatsApp, and everybody should know, including the judge, including all of us. So because when we all know that if I do this thing, I can be reported. Yes. Okay, and the report will be a thing that they know that it's me that I made the report. So there should be a place where I can make reports and it should be coded and that kind of a thing.
Treated seriously, and you are not afraid of being victimized or punished afterwards.
So I think there should be that kind of a infrastructure on ground they will now be. Yes, people might abuse it because somebody say because the judge look at me and say that I'm not wearing the black suit and go and report. Of course, when you do your investigation, you'll be able to know whether this makes sense, whether this petition or this report makes sense or it does not make sense. And if I make a false accusation, so then there should be penalty also against me too as a member of the public. That's the first point I want to make. The second point I want to make is that talking about transparency, because that is the next to the issue of corruption, transparency. I think the judiciary should be more transparent. It is difficult to know the budget of the judiciary in this country.
Oh yeah,
exactly.
Very, very difficult. Why? What are they doing there? What is the big deal in knowing the budget of the judiciary of your state? What's the big deal in knowing the budget of the judiciary? We got there was a judgment last week saying that governors should no longer take control of the money of the local government. What governors take every month is published on all social media.
So why not the judiciary?
It's difficult. So what's there? And if I be crying, there is no money. Say government is taking my money. They're not giving. We don't know whether you need more money if you don't know how much you are given. It's a very simple thing.
Exactly.
So the judiciary budget should not be in secrecy. Number two, again, I've always been a campaigner that judiciary should also carry the people along. And I ask the question: how many? Today is 15th of July. Let us even take January to June this year. How many criminal cases at High Court of Lagos? How many criminal cases between January and June this year have we gotten judgments? How many criminal cases are on trial, are presently part-hard? How many criminal cases?
I
We
think
need to know all
our
these things.
organization was coming up with something we
You
call
know,
justice clock.
So we get statistics, not only on criminal, okay, civil
all
cases,
cases.
on all cases, how many, and we get that report. What is bad? If after 6 months or if after 1 year, the CJ comes and issues a press conference. This year we got 395 rape cases, 3 of them, 500 of there was conviction of this, that. That's the only thing we have. Conviction of this. How many did you receive? How many got to trial? How many got to conviction? How many were struck out?
So we need
Why
to
were they
know
struck out?
what they are
When
doing.
people know all these things, it will boost the confidence of judiciary in the mind of the people. So these are things judiciary, they really need to work on. Then lastly, I want to say that for those judges and the ones appointing their brothers, their sisters into judiciary,
Their
I want to
whole
tell them,
family
the world is watching
Wow.
them. Those people that are there, the world, because that means they have a double work to do. They are now there, they have to justify that I'm there not because my father is a
Credibly.
CJN.
Yeah.
I'm there not because I am there because I am good. So for all of them, the world is watching them.
Wow. Thank you very much, sir. And with that, we have come to the end of this session. Thank you so much, Barrister Sylvester. Thank you, Barrister Fola. Your contributions have been very insightful. Until we come your way next time. Bye for now.